There are almost 11 exceptions to natural justice. One is by statutory provisions, the second one by the constitutional provisions, and the third one by legislative act, and the fourth one in public interest, and the fifth one in emergency situation, and the sixth one on the ground of impracticability of performance and in case of confidentiality, and number 8 in cases of academic adjudication, and number 9 when no right is infringed, and number 10 is in cases of interim preventive action, and number 11 in case of fraud. And these exceptions are not absolute exception to natural justice. As now we'll discuss the first one, exception by statutory provisions. The principle of natural justice may be excluded by the statutory provisions where the statute expressly provides for the observance of the principle of natural justice. The provision is treated as mandatory and the authority is bound by it, where the statute is silent as to observance of principle of natural justice. So silence is taken to imply the observance thereto. Thus, where the statute is silent as to observance of the principle of natural justice, the courts read into the provisions of the statute the observance of the principle of natural justice, and as such, these statutory provisions regarding exceptions are not absolute in certain cases. So, in this context, we'll discuss the very important leading case, and that is Delhi Transport Corporation versus DTC Mazdoor Congress in 1991. Supreme Court expressed that the validity of regulation 9 clause B of the Delhi Road Transport Authority conditions of appointment and service regulation was challenged. The regulation empowered the authority to terminate the services of a permanent and confirmed employee by issuing a notice without assigning any reason in the order and without giving any opportunity of hearing to the employee before passing the very order for termination of services. This regulation was held to be wholly arbitrary, uncalled, and unrestricted, violating the principle of natural justice as well as Article 14 of the Constitution. Public corporation or government company being state instrumentalities or state within the meaning of Article 12 of the Constitution, and as such they are subject to the observance of the fundamental rights embodied in Part 3 of the Constitution as to conform to the directive principle in Part 4 of the Constitution. The service regulation or rules framed by them are to be treated by the touchstone of Article 14 of the Constitution. Besides, the procedure prescribed by their rules or regulations must be reasonable, fair, and just, and not arbitrary, fanciful, and unjust. And in regarding the very exception by the constitutional provision, we'll discuss that the principle of natural justice may be excluded by the constitutional provisions such as Article 311, Clause 2 is notable. Article 311 provides protection to the civil servants. Article 310 incorporates the doctrine of pleasure developed and applied as it is a kind of pleasure that borrowed from the English rule and the crown's pleasure, as the crown is not bound by the contract of employment between it and the civil servant. Article 310 of the Constitution of India, which incorporates the very provision, every person who is a member of the defense service or of a civil service of the Union of or of an all India service holds any post connected with and defense or civil post under the Union. A person who is a member of a civil service of a state or holds any civil post under the state government as subject to Article 311. The protection of Article 311 is available to all persons in all India services, so the very protection is not available to members of the defense services. As regarding that, we will discuss the very leading case, and that is Union of India versus Tulsi Ram Patel, and it was decided in 1985 by the Supreme Court, and that is where an authority empowered to dismiss or remove a person or to reduce him in rank and satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry. And as regarding where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge, or where the president or governor, as the case may be satisfied, that in the interest of the security of the state, it is not expedient to hold such inquiry. So, as regards to Clause B, which stated above, it is notable that if in of such servant a question arises whether it is reasonably practicable to hold such inquiry the decision of the authority empowered to dismiss or remove such servant or to reduce him in rank shall be final. The finality given to the decision of the disciplinary authority is not binding upon the court so as to its power of judicial review is concerned, as it was decided in Union of India versus Tulsi Ram Patel in 1985 by the Supreme Court, and in another important leading case, that is regarding the state of Haryana versus Pyar Singh, the Supreme Court has held that in service matters, the role of the court is to ensure rule of law and to see that the executive acts fairly and gives fair deal to its employees consistent with the requirement of Article 14 and Article 16. For example, if a municipal corporation is established, the government is not required to hear the residents of the municipal area before taking decision for its establishment, because the very establishment of a municipal corporation is a legislative act and the rules of natural justice are not applicable to legislative acts. So, these three conditions, such as exception by statutory provisions and exception by the constitutional provisions and as per by legislative acts, the important one is State of Haryana versus Pyar Singh in 1992. The Supreme Court expressed the very legislative acts, and regarding that, in our upcoming video, we'll discuss regarding the leading cases Sitaram Sugar Company versus Union of India, a 1990 case judgment delivered by Supreme Court, and the Madras City Wine Merchant Association versus State of Tamil Nadu in 1994. So this judgment was delivered by the